Good morning and welcome. This is another in a series of webinars brought to you by the Private Business Services Group at Aird & Burles LLP. My name is Nick Torchetti. I'm a partner in the Corporate Commercial Department here, and I chair the Private Business Services Group with my partner, Cease Moffett. I will act as moderator of this session. Today's webinar title is Top 10 Legal Lessons to Learn for Private, Owner-Managed, and Family-Owned Businesses. So whether you run your business on your own with your family, with professionals, or whether you use a family office, and we've seen a huge explosion in family offices the last few years, whether it's single family, multifamily, or independent family offices, we think you'll hear some good information today. And we're lucky that we have some experts with us today in both corporate commercial law, tax, estate and will planning, and intellectual property. We are going to leave some time to answer questions, so please don't hesitate to send them in. Let me introduce our speakers in reverse order of appearance. First, Ken Clark. Ken is a mechanical design engineer by background, and he works with a number of groups at Aird & Burles. That is, he does both corporate commercial work and litigation. His practice focuses primarily on IP law, including trademarks, copyright, patents, and related areas such as internet law, which is very interesting these days, of course. Francesco Gucciardo. Francesco is our practice group leader in the firm's tax group. He's a member of the International Bar Association and the International Fiscal Association. Francesco's expertise includes the tax aspects of corporate transactions for both public and private companies. Marnie Pernica's practice is focused on wills, trusts, and succession and estate planning. She is a partner practicing in our tax group and the estate and trust group. And finally, Cecilia Moffett, who, as I indicated, is the co-chair of the Private Business Services Group, is a partner in the firm's corporate commercial group as well. She works extensively with owners of private companies on matters such as acquisitions, divestitures, and in respect of succession planning to the next generation of owners. So we're going to start with Cease. And Cease, just to open it up and try to get some discussion with respect to corporate lessons. My question to you is whether or not properly maintaining your minute book and corporate records is a concept that is overrated. We've seen a lot of lawyers who ignore that aspect of what we do. So is it overrated?
Thank you, Nick. And first of all, good morning to everybody. My answer is absolutely no. It's not at all overrated, especially if the minute book is for an operating business, but it arguably also holds true for a holding company. We have to remember that a corporation is legally considered a person. It can sue, it can be sued, and it can be held liable at law. If we look at Section 140 of the Ontario Business Corporations Act, I'm going to refer to it as the OBCA, and corresponding sections of the federal legislation, the CBCA, they require a corporation to keep certain corporate records, all of which are typically contained in the minute book. They would include the articles and bylaws, unanimous shareholders agreement, minutes and resolutions of directors and shareholders, including annuals, of course, various registers, a director's register, a securities register. A couple of new ones in the last few years. One is that now OBCA Corps have to maintain a register of their ownership in interests in real estate. And since June of this year, CBCA corporations must maintain a register of individuals with significant control. I won't go into the details of that, but we're expecting similar requirements will be added to the OBCA. Nick, there's various reasons why the minute book should be properly maintained and corporate records maintained, and they include obviously ensuring compliance with statutory requirements, for review by the accountants for audit purposes, to satisfy inspection by, let's say, CRA or WSIB if they come knocking and they want to do an audit, maybe to raise capital. And two important ones are as part of a due diligence review. If you're in a sale transaction, you want to do an M&A transaction, and the purchaser wants to review the book. And also, in actual fact, in case your book has to be produced in litigation proceedings. I actually have a file right now where we're making sure that all the shareholder loans and dividends have been properly recorded going back several years. And that's because the books have to be produced as part of a massive production of documents in the proceedings. It pertains to a former shareholder that is alleging they're entitled to more shares than they had. And valuation issues are obviously very important, so reflecting shareholder loans is necessary. We also recently had a client who brought us their minute book as part of an M&A transaction. We reviewed it, but we discovered it contained a set of articles of amendment that didn't do what they were supposed to do. The articles actually attempted to effect a stock split of shares. However, the articles inadvertently tried to effect a split of a class of shares which no longer existed. Obviously, in an M&A transaction, purchasers looking at it, and guess what? The equity, the shares, ledgers and registers don't line up with the constating documents. So we had to scramble to put in place corrected articles of amendment. Those take a few weeks to do. So I think the lesson to take away, or the message, is that keeping the corporate records up to date clearly avoids last-minute scrambles, and those can be very costly. Another point that I'll touch on as well, and I think they often get overmissed, or I see them being overmissed, especially in founder entrepreneur companies, are shareholder loans. They don't get properly documented. The founder's far too busy plowing money back to grow the company. But a shareholder loan should be evidenced by a promissory note or a loan agreement. In order to ensure they rank ahead of the unsecured creditors and trade payables, the corporation needs to grant the shareholder a security interest by entering into a form of security agreement, and they need to make the necessary registrations under the Personal Property Security Act to perfect that security interest. If the security is put in place after the fact, that's after a few million dollars have been advanced, but the corporation is now in financial difficulty, possibly on the eve of insolvency, an unsecured creditor could challenge the security as being under the Assignments and Preferences Act, and if successful, could have that security declared null and void. We actually recently had a client who had put millions into the company and ran up against that exact issue. They ended up being in special loans. They did come to us. We did put it in place, but it was risky.
Cease, I see that you're going to talk about shareholder agreements, and I'm glad you are, because it's a big part of what we do, obviously, and part of our practice in trying to get our clients to consider shareholders agreements. And I know in one of our previous webinars you discussed what should be included in a shareholders agreement. So I want to know, what are your thoughts on not taking the time to put a shareholders agreement in place or to periodically update it?
Well, again, Nick, as my heading says, hindsight can be 20/20. If either a shareholders agreement is not put in place or the shareholders don't spend the necessary time to think carefully about what should be included in it and also updating it. It is one of the most important documents, in my view, that the shareholders will enter into with respect to their shareholding interest in the corporation. And we have to remember that without it, their relationship is going to be governed by the applicable corporate legislation, which may not be ideal depending on the fact circumstances. I should quickly mention, as I did in a previous webinar, there is no such thing as a standard shareholders agreement for all situations. There are a lot of common themes, but each can be applied differently depending on the facts. But one thing that going through the exercise of putting a shareholders agreement in place, whether it's initiated, to be honest, by the founder of a family business who's considering and looking at the succession issues, if it's G2, looking at succession to G3. Maybe it's a majority founder with minority shareholders or even employee shareholders, or it could be a 50-50 startup. Many different scenarios. But at the end of the day, it forces all the shareholders to think about their relationship and the rules that should apply to that relationship, and it protects them in the long run. As I said, it's also something that should be revisited on a regular basis. Don't do it, park it, and then come back and look at it in 10 years. There should be a timeline to revisit it. I currently have a file where a shareholders agreement was put in place by the founder, and at the time she only wanted to address one issue, which was what happened to the shares held by any one of her adult children if the child passed away. She was adamant that the agreement didn't need to address any other issues, such as corporate governance, the ability of her adult children to buy each other out, and her vision was that the kids would work together amicably in the business. As we all know, that's not always the case, and in this situation, one of the siblings has decided they don't want to be involved in the business any longer and wants to be bought out. But the agreement doesn't provide for that. And as a result, it's resulted in a relationship amongst the siblings that has become quite strained. Obviously not something the founder ever wanted to have happen. I actually have another recent file, and it was a startup between 50-50 partners, and they each put in excess, in excess of $1 million for the startup, but they never put a shareholders agreement in place. Now, our client came to us, and I will say, came to us after the fact, and they got to the point they didn't want to inject any more money. The other 50% partner did. And our client, not realizing the ramifications, agreed to dilute his equity interest to 40%, still without a shareholders agreement in place. And the result of that is that the relationship is governed by the OBCA, which was not favorable to our client because he's now holds less than 50%. And the relationship became strained. Our client ended up being removed from the board, being diluted, and had no ability to force a buyout of his shares. So, the lesson to be learned is he should have looked at this earlier. Also, his shareholder loans weren't properly documented, so there was an issue about whether it was equity or whether it was loans.
So, the shareholders agreement has a big impact as well on exit strategy. We've heard a lot about exit strategy. It's a theme today. It's been a theme in a lot of what we do. Are there aspects of that owners are struggling with?
Yeah, Nick, I would say there are. I mean, in the case of a family-owned business, the founder and even successor generations who are active in the business need to consider what their exit plan is if they want to retire, in case, unfortunately, they die, or if they become totally incapacitated. And what we're seeing is that many family businesses don't have a plan in place, or if they do, it actually might be very antiquated and outdated. Without one, it can result, again, in family tension and fighting and be very divisive. I talked about the one sample earlier about the shareholders agreement, but again, it's all part of the bigger plan. Any plan should be developed bearing in mind that maybe the second and third generation don't always share the same values as the founder. And so, my message is that it is extremely important to plan for succession and to consider, from the founder's perspective, what that looks like. Is it a family member who has the skill and drive to carry on the business? Should it be a management shareholder? Those are more rare. Or could it be a third party? Has the founder recognized there's no natural family successor? So, do they make the decision to put the company through a sales process and find a buyer? Again, I've got a client that has planned very well for all of this, and it's working with well-thought-out shareholders agreements and wills, and it'll pass to Gen 3, one of Gen 3, leaving the other 4 out, but they're all very content. So it's something that has to be carefully considered.
Thanks very much, Cease. We're going to go over to Marnie, and Marnie, your topic can be a huge issue, but hopefully it has a simple fix. So tell us about dying without a will to start with.
So thanks, Nick. And I'm going to apologize in advance. I always say this to clients is, we're going to talk about death and dying, and it's not unfortunately, if, it's a when. So, let's just all get on the same page about what we're talking about for the next 10 minutes. So dying with a will, generally, there's this misconception out there that, the fear is you die without a will and everything's going to go to the government. So as a general statement, that's only going to happen in very extreme situations where there's no next of kin, because there is the Succession Law Reform Act in Ontario that kind of sets out what happens if you die without a will. And one thing I'll say is, while it won't go to the government, if you have a spouse and married spouse and kids, everything's not going to go to the spouse either. And I think that's another misconception that's out there, is that if I die without a will, my spouse is going to inherit everything, so it doesn't really matter. So I've given kind of a case example in the first instance that we're going to go through to illustrate in this kind of, I want to say, standard scenario that I see often, where you have, a husband and wife, 2 kids, one's in the family business and have been told to do some creditor protection. And as a result, everything's in one spouse's name. It's a relatively common scenario. So the question is, what happens if you die without a will? And I've got a couple slides. So if you have a spouse and no kids, everything will go to the spouse. If you have a spouse and kids, and that's where, most of the time it happens, in Ontario we have what we call a preferential share. So the spouse will take the first $200,000 in assets, and depending on how many kids you have, the remainder will get split effectively one of two ways. If you have one kid, there's going to go 50 to the surviving spouse and 50% to the child. If there's more than one child, the spouse will get the first $200,000. 1/3 of what's remaining will go to the surviving spouse, and the rest gets divided between the kids. My slides, and you'll all have my slides and can see my slides, go on to talk about what happens if there's no spouse, no issue, et cetera, and it kind of just goes down the line. But what I do want to highlight in my next slide, or my last slide on this issue, which is intestacy rules in action, to the extent you take this scenario with Brenda passing away, owning the assets the way she does, Bob will get the first $200,000. And the key thing here is Bob will get a remaining 1/3. Melissa, who's over 18, will get another third. And Taylor's under 18. And this is kind of the crux of the unfortunate scenario of dying without a will sometimes, is because Taylor in Ontario is under 18, and 18-year-olds can't get more than $10,000 in their name. So their inheritance is going to get paid into court. The Office of the Children's Lawyer is going to manage that inheritance until they turn 18, at which point in time Taylor's going to walk away with the whole of the inheritance. One thing I just want to stress is, to the extent Bob's net family property, and that's a family law concept, is greater than what he gets on an intestacy, he can choose to take as if they got divorced, effectively. So there's a choice for married spouses. These are kind of my words of wisdom. Common law spouses do not take on an intestacy, so this only works if you're married. Separated spouses do. So if you're getting separated and you're not divorced, your spouse will take as if you were properly married. Marriage revokes a will. That's kind of a critical one, is people think they have a will, they get married, they no longer do, unless it's made in contemplation of marriage to a specific person. You can't distribute the way you want. No, it's not going to go to the government, but the distribution may not be how you want it to be. And there's the potential, and this is the big one, for unintended tax consequences, which I'm kind of just going to naturally flow into my next slide.
The probate. I want to talk about that, and just as an introduction, because Cease and I, in our corporate practices, as we act for, owner-managed businesses, we find that we're, again, the last few years, dealing more and more with exit strategies, dealing more and more with introducing to our estates group the structures that we have in place for our corporate clients, and with your help, doing some probate planning. So I guess, to me, that's a great lesson to move to. It seems to me that probate planning is a great place for a private business owner to look at and see some savings.
Absolutely, absolutely. So this is kind of how I always start out my meetings with clients, is let's give a 30-second kind of summary on death and taxes if you die in Canada, resident in Ontario. So we start with income tax, which is not probate tax, but in Canada, when you pass away, you're deemed to have disposed of all your assets at fair market value, and you pay the resulting capital gains tax. The very simple example is you bought a share for $1, and it's worth $100. When you pass, you have to pay tax on the capital gain. That tax can get deferred if you leave everything to a spouse. Here, a common law partner counts, either outright or in a qualifying spousal trust. Not really getting into those, but that's the income tax conversation. And there's ways to defer the tax. The estate tax, the estate administration tax, so that's a different tax. That's an Ontario tax, and that's levied by the Ontario government. Effectively, everybody calls it probate, but it's actually called estate administration tax. And what that is it's the process of taking the will to court with a death certificate, and the court handing back a piece of paper that says, yes, this is the executor, and this is the person who's in charge. In order to get that piece of paper, there's lots of delays right now, about 6 to 7 months in Ontario until you'll get it, but you also have to pay probate tax. And probate tax, when you look at it kind of very high level, is $15,000 per million. So as soon as you have to apply for probate, you have to pay probate tax. The only debt that is deducted from probate tax is a registered mortgage on property. So to the extent you pass away with one will and any assets that require probate, you're going to pay the probate tax. So probate, as I think I kind of alluded to, only applies in certain situations. So when does it apply? Again, jointly owned property generally passes by right of survivorship if it's true joint ownership. So we're talking about assets that are owned in an individual's name alone. So real estate in Ontario, large bank accounts, non-registered investment accounts, and shares in public companies. Generally speaking, the institutions and land titles won't let you transfer the assets without getting the certificate. Shares in a private company, however, if a third party, if another shareholder is not demanding probate, you don't need it. The problem is, if you pass away without doing proper probate planning, as soon as one asset needs probate, all of your assets need probate. It doesn't matter if the third party is demanding it or not. So we've got lots of plans. So these are the very, very high-level summaries of the plans that we can do to avoid estate administration tax. So the first is with respect to registered plans. So registered plans in Ontario allow you, and insurance, so registered plans and insurance, you can do a direct designation. You can do a direct designation either in the document itself, or you can do a direct designation in your will. A direct designation, the institution will pay out the funds without requiring probate. So a direct designation will get you out of the probate fees on life insurance and registered plans. I will caution, one thing that I'm going to caution quite strongly on, and I have great respect for advisors, but the insurance designation forms aren't sophisticated. They say name a first beneficiary and name an alternate. They can't provide for the type of trust terms that are required. So for example, and I'll use me as an example, I had insurance. I appointed my husband in the first instance, and I had been advised to appoint my child as the alternate. And this was before I was well versed in this area of law. And 6 months ago, I went back and looked at it and recognized, okay, only my daughter's named. I have 2 now. And secondly, my daughter's under 18, and my insurance policy is more than $10,000. So God forbid something had happened to my husband and I, only one of my kids would have inherited, and the Office of the Children's Lawyer would have been in charge of it. So I caution against relying on the insurance forms themselves as a way to avoid probate. In my opinion, paying the $15,000 is better. But we can do planning for that to avoid it altogether. Joint ownership. This is a big one that pretty much comes up on a daily basis. Oh, I own everything jointly with my mom, so we don't have to pay probate when she passes away. And again, unless it's true joint ownership, whereby mom and daughter own an account that is truly both of theirs, that plan does not work. Again, if one asset needs probate, all assets need probate. And to the extent probate's required, that estate trustee has to swear that they've included all of mom's assets. So if that bank account is truly mom's, doing joint ownership won't get you out of the probate regime. I'm going to talk about the primary secondary will structure in a second. That will get you out, but I caution heavily against relying on joint ownership to avoid probate. Again, if you're going to do it, make sure you get proper advice to paper everything properly. I do talk about the risks and rewards of joint ownership. I'm kind of going to leave it at I don't like this planning. Joint account owners have equal rights. They can go to the bank. They can withdraw funds. Creditors don't know that it's not a true joint account if it's not a true joint account, so you could open it up to your daughter or son's creditors or divorce proceedings. You lose control. There's potential income tax consequences you can't gift to kids tax-free. So to the extent you're truly making an account joint, there's income tax consequences. And again, I've bolded this because this is the critical one. If you have one will and one asset needs probate, these joint accounts are going to be included in the probate application. And they are ripe for litigation. Everything's well now, and when somebody passes away, things can go wrong. I don't want to spend too much time on this one. These are the alter ego trusts and joint partner trusts ones. This is for individuals who are over 65 and want to do some probate planning outside of will planning. These are income tax concepts. They're created under the Income Tax Act. And effectively, what it is it's taking assets out of your name and putting them into a trust structure. You are still the beneficial owner of the assets you're the beneficiary of the trust, but true legal ownership transfers into a trust. It's an effective way to avoid probate. Everybody's comfortable with these, but with the new, and we're not talking about this now, trust disclosure rules that are coming in 2021, people are shying away from them because the CRA is going to ask a lot of questions about beneficiaries under these structures. This is the next one, which is the primary secondary will concept, which is what I probably do 80% of my time. Effectively, Ontario has a regime whereby you can have 2 wills instead of 1. And what we do in this structure is we take assets that need probate and we put them in the primary will. So we take real estate that's personally held, non-registered investment accounts, and bank accounts, and we put them in. Effectively, somebody will walk away with 2 wills. And the first will deal with the assets that require probate, and the second will deal with assets that don't. So shares in the private company, which is often where the value is. And effectively, if you need probate, the way that the wills define the assets that fall within it, you only need to pay probate on the assets that need it, and everything else can shift into the secondary will. So we do quite a bit of savings there. It's a very common plan. And something that I recommend for anyone who has shares in a private company.
Great, thanks, Marty. I'm sure we'll have some questions about that because that's an area we see a lot of work in. We're going to flip over to Francesco. And Francesco, you have about 10 minutes to cover all the tax issues facing small businesses and their owners. I mean, we had a whole session on this once, and we didn't even skim the surface. But if you can give us some of the key tax considerations business owners should be aware of and deal with today, given that their main focus is actually trying to run a business. For example, again, exit strategy, exit planning. Estate freezes have been all the rage over the last several years. This is another area where I know Cease and I have been heavily involved with the tax group, with the estates planning group, planning estate freezes for our clients. So can you tell us some of the tax lessons learned in planning for for tomorrow, I guess?
Sure, Nick, and thank you very much for that. Look, the subject of small business taxation in the context of a closely held owner-managed business is both broad and varied. There are so many traps and pitfalls and technical rules that apply that can leave clients bewildered. From navigating the association rules, which are relevant to whether and how the small business deduction might be shared or split between associated corporations, and managing passive investments, which might grind your small business deduction, to working through the recent changes to the intercorporate dividend rules, which have complicated tremendously the simple proposition that corporations can pay tax-free dividends between them, to navigating the recently updated tax on split income, or TOSI rules, which significantly expanded the old kiddie tax rules to understand when and how a corporation's dividend stream can be shared among family members. Each of these, as Nick alluded to, is a full seminar topic on its own. What we're going to talk about in the next few minutes are some fundamental business succession and exit planning considerations from a tax perspective, which we have broken down into 2 basic lessons. Lesson 1, it's never too early to plan for death and/or succession of the business. In this connection, we're going to look at some tools that can be used to minimize and defer the tax a business owner will realize on his or her death, and find options for funding the liquidity requirements needed in order to pay that tax. And lesson 2, it's never too early to plan for a sale, or at least it's prudent to monitor certain tax attributes if a sale might be in the horizon in the next few years. Regarding the first lesson on succession planning and death, if you're not already aware, and as Marnie alluded to, all of us will be considered to have disposed of all of our assets on our death for proceeds equal to their fair market value at that time. In other words, we're treated as if we actually sold all of our assets for cash and received the price for those assets that we would likely receive on the open market at that time. The only real exception to this rule is where you leave those assets to your spouse or in a spousal trust, as Marnie had already told us. In that case, this deemed sale rule does not apply to those assets as at the time of your death, but will apply as at the time of your spouse's death. But any gain realized as a result of this deemed sale will be subject to tax at normal rates. Well, what's the implication here? Well, if you own shares in a successful company with a significant accrued gain, you and your family will pay tax on the gain inherent in those shares as at the time of the later of yours and your spouse's death. Clients often ask us how they might control the runaway train that is the growing value of a successful business. In other words, is there a way to avoid or defer this tax? The most common tool that is used in planning for succession and death is, as Nick said, the estate freeze. By executing an estate freeze, you're able to stop the value of any shares you own in a company from growing in your hands, so that the future growth, that is, the growth in the value in the company that might take place from the time you execute that estate freeze to the time of death, accrues to the next generation, such as your children or grandchildren, while always maintaining control of the corporation. That's a lot of words, so let's look at a simple example. Okay. On the left side, we have an individual who's a founder of a business, wholly owns the business, Company X, and it has a current value of $7 million. That individual or founder does nothing, and we presume that that individual or founder dies in 2040. When we look at 2040, and the value of the business has grown from the $7 million to $35 million. That individual on his death, or her death, will realize a $35 million gain in 2040, which equates to a $9.367 million tax liability that needs to be funded. So what does an estate freeze do to help this situation? Well, before we go into that, I'll describe very basically how an estate freeze works and what it is. The individual in the present day having shares worth $7 million would participate in a reorganization of the business of Company X. That individual would take his $7 million worth of common shares, exchange them with Company X for fixed value preferred shares that have a redemption value of $7 million. So now the value of that individual's shares are frozen in time at $7 million. At the same time as that exchange occurs, a family friend or trusted friend comes along, takes $100 of his or her own money, and subscribes for the new common shares of Company X. By definition, those new common shares issued will have a value equal to that $100 subscription price at the time of the freeze. That family friend then gifts or settles those shares on a trust that is for the benefit of the individual's family, typically. So at the end of regulation time here, what you end up having is the individual with frozen shares worth $7 million and a trust having beneficiaries being the family of the individual, owning common shares that, as at the date of the freeze, are worth only $100, but when we look to the right side of the slide, as at 2040, those common shares pick up the additional value that takes the company from 7 to 35. So in 2040, at the time of the individual's death, the shares owned by the individual are worth 7. The shares, those common shares owned by the trust, are now worth 28. Well, when the individual dies, it's only the shares the individual owns that is subject to what we like to refer to as the death tax, quite morbidly. So in that example, we've frozen the gain at $3.5 million for a $1.87 million tax liability, and the common shares which grow end up in the hands of Generation 2 or Generation 3, which are expected to die much later and therefore defer the death tax. Now, let's talk about actually funding the death tax liability that remains or taking steps to eliminate it. If your company is flush with cash that it doesn't need, or you can afford paying the tax associated with distributing it, or, better yet, have a crystal ball so you can extract it before you die, great. However, many clients are not so lucky. And in that case, a corporate life insurance policy can act as a tool to fund the death tax in a very efficient manner. We don't have time to go through the nuances of various strategies. But what you should know is that the proceeds of a corporate life insurance policy are received by the corporation tax-free. And the corporation can distribute those proceeds to individual shareholders tax-free, or use those proceeds to create tax attributes to reduce or eliminate the inherent tax gain on a tax-free basis. The simplest strategy involves completing an estate freeze as already described, anticipating and estimating the inherent death tax liability in the frozen shares, and taking out a life insurance policy that will provide a payout at least equal to that death tax liability. On death, the proceeds will be paid out and will be available in the corporation and ready to be paid out tax-free to generally cover the death tax. Other strategies, such as the one described on the slide, involve taking out a policy equal to the value of the frozen shares instead of the estimated amount of the death tax liability. We're very happy to take you through the pros and cons of various options. Regarding the second lesson on planning for a sale, as you probably already know, individuals are currently entitled to a lifetime capital gains exemption that currently sits at approximately $866,000 of gain on the sale of qualifying small business corporation shares or QSBC shares. Most people recognize this rule and equate it with a capital gain exemption on the sale of the shares of their small business. That's about right, but with all things tax, there are technical rules that need to be followed. If your business has been quite successful and is flush with cash, or was flush with cash and some retained investments leading up to the time of sale, then you need to be aware of the following two technical rules. First, in order to access the exemption, more than 90% of the assets by value, as at the time of the sale, must be assets used in a business carried on primarily in Canada. Second, throughout the duration of the 2-year period leading up to the sale, more than 50% of the assets by value must be active business assets. Here's a simple illustration of these two rules in action. On the left side, we see that the second test is met throughout the 2-year period. If you look at it, at all times, the active business assets represent more than 50% of the active business assets of all the assets of the corporation. But let's look at the 90% test. 1 month before the sale, just shy of 60% of the assets are active business assets. So in order to meet the 90% test as at the time of the sale, you need to take steps to extract these bad cash and investment assets from the corporation so that 90% of the assets are active business assets at the time of sale. Let's look finally to the right-hand side. Well, we look 12 months before the sale, we have too much excess cash and investment assets in the corporation that are not used for active business use. We're below the 50% threshold. So any steps taken as at the time of the sale to purify the corporation and access the capital gains exemption will be futile. You will fail the 24-month test and will not have access to the exemption. So this is why lesson 2 is it's never too early to plan for a sale. You should always monitor the assets in your company, excess cash, the value of investments in order to ensure that if there is a sale, you can take steps to qualify the exemption. One final 15-second point that people often miss. As they expand into other markets, it would be a mistake if you seek the capital gains exemption on exit to incorporate a foreign company to be held by your Canadian operating company. The reason is the shares of that foreign company will be a bad asset for these purposes. And if the value of your foreign company exceeds 10% of the total value, the total enterprise value, you're not going to meet the test at exit.
Great. Thanks very much, Francesco. I hope everybody got that and all the details. I mean, the devil is always in the details, and obviously this area is a little bit more complex, and hopefully you speak to your advisor before you start taking any steps on your own. The next area of business is intellectual property. And Ken, your materials certainly indicate that all companies have trademarks, but should intellectual property really be a substantive concern for every private business? We don't seem to concentrate on intellectual property. They're more interested in running their businesses, worried about shareholders agreement and maintaining their corporate records as they should be. Tell us about why we should worry about intellectual property.
Well, first of all, Nick, it's got nothing to do with death or taxes.
Good.
So hopefully it'll be a little less morbid in here on
And a lot more
beautiful
fun.
Thursday
I would
morning.
assume, sure.
So intellectual property is important for all businesses because while companies are growing and these are family businesses we're talking about today, people do have better things to do than worry too much about their IP. And given the time, I'll just maybe flip forward to an example. If you could flip to the A and B slide. And I want to show you our graphic of our wonderful old logo from the 80s. And that is...
There it is.
Just look at it. It's a paragon of design. And you know, you'd think large, sophisticated organizations like major downtown law firms would know better than would know where their intellectual property rights lay. But it turns out that our logo, the A&B's big logo in the 80s, early 90s, was not owned by Airden Burles. It was actually owned, the copyright, and it was owned by our graphic designer. And this was back in the days when business cards and brochures were all done by printing houses, and the logos were often designed by these same people. And if you don't cross your T's and dot your I's, turns out that the graphic designer owns the copyright in your logo. And despite the fact that you paid them for it and that you've had a contract with them, they can in fact control to some extent how your logo is used. You might notice we have a new logo at the bottom left of that slide.
Do we own that, Ken?
Hopefully. I'm sure we do. And this is emblematic of one of the common errors that business owners make, is that, you know, they want to get a snazzy logo for their business, and they go and get a graphic designer, because most businesses are not graphic design businesses. And it turns out that unless you have proper agreements, then the copyright belongs to the designer. So that's one common thing. And I've actually had a case or two where you know, businesses that we represent have had problems with people copying their logo or making variations on their logo, or coming up with similar brands down the street from them. And because they hadn't registered their trademark, or they hadn't properly done their contracts with their graphic designer, then there was a dispute, and it made it very difficult to resolve the dispute. If we can go to the next slide. Then one of the things that businesses also tend to skimp on in the early days when they've got businesses to run is employment agreements. And one of the most important things a business can do, especially midstream or when you're a mature business, is regularize your employment agreements to deal with things like intellectual property. A lot of businesses don't register their IP, but they have a lot of valuable goodwill. They have trade secrets, they've got confidential information, and these aspects of their business, their customer lists, their intellectual property, are all things that need to be protected by confidentiality agreements and employment agreements. If you're a technology business and you're creating new intellectual property that maybe is patentable, you have to make sure to have these confidentiality agreements in there to protect yourself in case your employees leave and go join competing businesses or things like that. And so I often see that family businesses operate on the honor system, and they hire people, and typically that works out, but it's the bad apple every now and then that upsets the cart. And you have to be careful about that kind of thing. And regularizing your agreements, you know, at the end of the year, you can have an IP policy and get people to sign things. And it's not that onerous, and people will accept it. And it really avoids some of the serious problems that can occur in businesses if they don't take these steps. One of the other things I see are problems with domain names. Often a business will have a website, or it'll have nowadays social media outlets, and they don't take the time, or they don't have the resources to necessarily check to make sure that their variants of their names are chosen. We've had a number of cases where the .com versus the .ca has shown up, and of course there's the Google problem where your business is now not showing up at the top of the Google list because some rogue has come in and purchased all your keywords. So while that's not strictly legal, you have to keep your mind open to the fact that the world is different now. Advertising's done in a different way, and you have to be aware that people will try to encroach into your space. So we recommend having an IP policy, having a plan for your intellectual property, protecting your trade secrets, protecting your confidential information, protecting your goodwill, making sure that you have your agreements tied up either with your graphic designers or your contractors or your employees so that the IP belongs to the company. And this is especially important when you are selling your business or you're transferring your business along. You want to make sure you've got all these loose ends tied up because That will be something that will be top of mind for purchasers. They always check the intellectual property. They want to know that your brand has been registered, and they want to make sure that they have an asset which they are purchasing that is protected. And primarily that's your reputation, of course. The key asset to everyone's business is its reputation. And without registering your trademark, without making sure your employees are properly contracted, then purchasers are going to see some risk, and they're going to be discounting the purchase price based on that risk. Other things to consider are patents. A lot of technology businesses or businesses with new ideas can consider patenting them. Trademarks are worth registering. They're not that expensive. They're $2,500 or so as a budget. Patents are more expensive. They're in the $25,000 range. But if you have a new invention that is the core of your business, or if you've come up with a new widget that is going to change the world, then you really should consider patenting that. That gives you a monopoly on the sale of the widget or the provision of the service that you've managed to turn into a process. And those things should be considered, especially with more mature businesses or even startup businesses. Often the core of their business is a new product or a new technique for doing things, a new manufacturing method, and all those things can be protected. The key there, once again, it all comes back to your employee agreements, because you got to keep it confidential, and the way to do that is through these agreements. And so you want to make sure that your employees don't take all that they've learned at your company and go off and start their own business and unfairly compete. So your agreement should also consider limited anti-competition clauses and especially non-solicit clauses. We all know that it's difficult to enforce non-competes, but if you make them limited and you make them time limited and geography limited, they can be effective. And those are all things to consider when we're talking about intellectual property. And I think I'm coming up to the end of my time here, so be happy to pass that over to answer some questions.
Thanks very much, Ken. And we do have some questions coming in, so maybe we will get to the questions before we summarize. Marnie, there were a couple questions for you with respect to intestacies and dying without a will, and we know that's a big issue. We've confirmed that.
I may be morbid, but I'm often a very popular person at a dinner party.
I question whether people are enjoying their conversation necessarily.
With me, always. No, so a couple of the questions came in about intestacy, and as a general statement, I'll say you can't force a beneficiary to take a gift. And so one of the questions was, can children disclaim an interest on an intestacy? So I've never seen everybody disclaim an interest in favor of mom, but you could if you're all of age of majority, and it would kind of just flow that if none of the kids are taking, you would be deemed to have died without issue. Now, I'm not going to get into details because it's not a file, but arguably, if those children had issue, I can't answer the question right now as to whether or not the Office of the Children's Lawyer would also have to get involved in that type of a situation, because they should be taking under intestacy laws. So
adult children who have children.
Who have children, whether or not the Office of the Children's Lawyer would have to get involved in that conversation. And in terms of on an intestacy, who's in charge, the problem with intestacy is you have to apply for probate, even if you don't think you need to. For example, you can't sign a tax return. There's no legal representative to file the final tax return without getting somebody appointed by the court. So there's no default person. Somebody has to apply to the court, and the family's kind of got to pick who's going to do it and apply for probate and the certificate itself. Two of the questions relate to probate, and I'll say we have lots of planning techniques. Principal residences is a planning technique that we put in on a daily basis. To get it into the secondary will, it involves using private companies and transfer of legal title and beneficial ownership, which isn't what we're talking about today, but the answer is yes, it can be done if you have the proper advice. And again, I'm going to highlight or emphasize the fact that probate's only required if a third party demands it. So to the extent you hold assets with an investment advisor that's going to let you do it without probate, as long as you have two wills, you're probably good. But again, one asset needs probate, they all need probate.
Great. Great. Thank you, Marnie. Cease, one of the questions which I think is overarching, and it goes to maybe the crux of what we've been discussing today, is what are some of the pressure points or catalysts for owner-managed businesses?
Well, again, I think, Nick, as we have been discussing, some of the pressure points for owner-managed businesses are really making sure that your house is in order. Have you got the necessary agreements in place, whether it be a shareholders agreement or whether it be your wills, so that you have planned for the transition of your business to possibly Gen 2 and maybe even Gen 3? Secondly, as Francesco was speaking to you today, it's important to look at all of that in the context of your tax planning. And again, there is no one fit, as we all know, for every family business or the circumstances in the manner in which that family business was founded, what's been put into it, et cetera. So I think the pressure points are everything that we have been talking about today. And, you know, founders get so busy growing their business. They're passionate about it. You can never take that away from them. But they sort of need to come and speak to their professionals and talk about death and dying and, and all those horrible things, just to make sure there's no surprises, because you actually, you never know when, I hate to say it, but your ticket's up.
The other not very nice thing to talk about usually is the third D, which is divorce. And one of the questions came in as to how does a second-generation divorce affect the family business? And I guess, you know, the assumption is if you've done a freeze, then second generation and third generation are likely still beneficiaries of a trust. And hopefully, as we've indicated with the deed of gift earlier, you've done some planning that way so as to avoid any issues with second-generation divorce. If shares have already gone out to a second generation by any means whatsoever, distribution out of a trust or under a will, then I guess the question goes back to, again, one of the major themes that we've talked about both today and previously, and that's with respect to shareholders agreements and how you deal with those.
Right. And actually, Nick, I thought you were going to give me that entire question, but that's okay. The question that we got from our listeners was how second-generation divorce can affect a family business. And obviously, all the emotional issues aside, because any divorce in a family setting is disruptive, but talking purely from a contractual and a business perspective, again, if there is a shareholders agreement in place that addresses that the shares actually do not go to somebody who is no longer a spouse, and in our shareholders agreement we actually define a spouse to exclude somebody that is either divorced or you're subject to a separation. So if the shareholders agreement is in place, that will protect the family business. We have clients as well that if a spouse ends up somehow, because the planning through the wills and gifting, et cetera, was done incorrectly, so that unfortunately the shares fall into net family property and they are not treated as excluded property for family law purposes, so they arguably become the subject of what is an equalization payment for family law purposes. We do go the step of saying, well, fine. If the spouse is actually, there's risk they'll get their hands on those shares, then we have provisions in the agreement where they're bought back, and the spouse cannot have the shares because you can imagine it would be incredibly disruptive in the context of a family business for an estranged spouse to then be having a say in the business.
Great, thank you. Francesco, we have a couple questions. Well, actually, thanks to Sarah, wherever you are, for pointing out a typo on one of our slides. We'll get that fixed up. I think she pointed out slide 29 or 30, and Francesco just gave me an oops, and we'll fix that. Francesco, there is a question for you with respect to shares qualifying for the capital gains exemption once you've done a freeze.
Yeah, that's right. So it's a great question, and the illustrations at slide 29 assume full gains, full tax. But the question was, well, if you've done a freeze and the founder who owns the frozen shares dies and the shares at the time of death qualify as QSBC shares, will the founder be entitled to claim the small business deduction in respect of the first $866,000 worth of gain? And the answer is yes. And I'm going to be a tax lawyer or a lawyer and say it's generally yes. If the estate freeze is your garden variety estate freeze, where the interest holders in the company are all related post freeze, then yes, you'll be entitled to the capital gains exemption. If other parties are involved in a freeze and hold other shares, then there are certain additional terms and requirements that must be met in respect of those frozen prefs in order for you to claim the benefit of the CGE and the QSBC share exemption.
Great. Hopefully that answers that question. A couple other questions. One is, I'm going to try and distill it. When an adult married child subscribes for shares, is there any documentation available other than a formal domestic agreement between the spouses? I think that says. I think that question may be related to protecting assets from net family property. And you've heard, again, one of the planning tools is the gift and ensuring that a deed of gift is actually used if there's going to be either a gift of shares once they're subscribed for by a parent usually, and then are settled on a trust by way of deed of gift to ensure that the shares and as they increase in value are excluded from net family property. I think that might have been...
Yeah, and Nick, I mean, they could be gifted directly
Right,
to the
right,
child. It
right.
doesn't have to necessarily be
yep,
settling
we've
it
done
on
that as well.
on a family trust.
So forgive me if we've said this in this webinar, but I just want to highlight the fact that when we're talking about excluded property, gifts that are received after marriage are excluded. So I just wanted to highlight that for everyone. So to the extent you're married and then your parent gifts you shares, those are excluded property for family law purposes. So that's kind of the basic premise upon which we're talking about. And to the extent it's where oftentimes an estate freeze can come in is if a child does own shares before marriage. There's a date of marriage deduction with respect to the value of the shares. And if you want to kind of freeze that growth, because it's the growth from date of marriage that's subject to family law claims, oftentimes clients will come in when kids are refusing to do domestic contracts, or if you don't want, full financial disclosure, which is required for a domestic contract to be valid, clients will come in and do freezes. So it's kind of the pre and post marriage freeze and settling of a new trust to deal with that issue as well.
Yeah, and Marnie, I've had clients that have done exactly that. They don't want to have to do the full financial disclosure to the new spouse or to-be new spouse, and so they will do exactly that planning. They'll do the freeze, and then they'll do the gift after marriage and avoid having to go the route of the domestic contract.
Yeah. So that's something we do all the time.
Yeah, we've done that as
And I
well.
work with Marnie all the time.
Yes, we work
See,
together often.
Can you just expand a little bit, even using a deed of gift for cash or outright to a child or to a relative, and how that...
In what sense do you mean, Nick?
Just whether it's part of a plan, whether it's part of a family way of dealing with assets or dealing with cash, and excluding that from net family property.
Well, and again, I mean, it's all part and parcel of, there's a combination of doing your planning in conjunction with your wills, and then planning for what would happen if the worst case scenario happens. So deed of gifts are used extensively for family planning, so that you end up not having to put, exposing the shares, to a spouse.
I want to add one comment on the cash thing. Gifts of cash after marriage with a deed of gift is great. If your child uses it for the matrimonial home, you've lost the protection.
Lost it.
Oh, okay.
I just want to put that out there.
I missed your
I
comment
wanna-
about the cash. Yes.
In the few seconds that we have left, I want to wrap up a couple things. One, I think there are 10 lessons. Maintain your corporate records, enter into a shareholders agreement and review it, assess the impact of transferring your business to the next generation, make a will no matter how old you are. There are some basic and effective tools to do probate planning. Use them. It's never too early to plan for death and succession. It's never too early to plan for a sale. Be aware that your design consultant likely owns your copyright. Airden Burles learned that. Use employment agreements to protect your IP rights and register your trademarks. And before we wrap up, a couple things. There is a webinar coming up on December 4th at 9 a.m., Tips and Pitfalls for Acting as an Attorney for Property and Personal Care, which would be good information to have. And finally, the continuing professional development code for this webinar, as well as the general follow-up, including slides and audio, hopefully a fixed slide, audio recording, will be up in about a week's time. Okay. So thanks, everyone. Hopefully we got to most of your questions, and hopefully you found this helpful. Have a great day.